Federal prosecutors are conducting an active investigation involving individuals connected to the president. That fact is not disputed. It is documented. It carries legal consequence. The inquiry does not center on rhetoric or politics. It centers on conduct, on financial relationships, on the use of access. When criminal investigators move beyond review and into active development, the system has already shifted. Process replaces speculation. Evidence replaces narrative. This moment matters because the investigation intersects with executive power, foreign policy, resource access, national security framing. These are areas where discretion is broad and oversight is thin. That combination creates risk, not political risk, institutional risk. The Constitution assumes separation between public duty and private interest, between enforcement and influence. When those lines blur, legitimacy weakens, trust erodes quietly, often before outcomes are known. What makes this phase distinct is proximity to policy, to decision-making, to benefit. The closer those elements move together, the more the legal system is compelled to act. Federal prosecutors expand inquiry into Trump-linked associates. Federal prosecutors expand inquiry into Trump-linked associates. The investigation has moved beyond preliminary review. Subpoenas, witness interviews, and document requests are now central. The focus is not presidential conduct directly, but proximity to power. Associates with access, influence, and policy awareness are under scrutiny. This phase signals evidentiary confidence, not speculation. Federal prosecutors typically advance only when legal thresholds are met: probable cause, jurisdictional clarity, defined statutory exposure. The expansion suggests investigators see a coherent factual pattern, not isolated transactions, not coincidental timing, but a sequence of actions linked to policy movement. Such cases often test conspiracy statutes. They examine coordination, intent, and benefit. They rely on communications, financial records, and intermediaries. The legal risk grows as more actors are added. Each link strengthens or collapses the chain. This stage also increases pressure on institutions. Courts, oversight bodies, and enforcement norms become active constraints. Silence is replaced by procedure. Discretion narrows. The process becomes harder to reverse. Financial ties to Greenland mining firms under review. Investigators are examining ownership structures, investments, and advisory roles, direct stakes, indirect holdings, shell entities, partnership arrangements. The issue is alignment between private financial interest and public action. Rare earth mining elevates the analysis. These resources intersect with defense supply chains, technology manufacturing, strategic trade controls. When policy advocacy overlaps with private exposure, disclosure rules apply. Failure to disclose becomes material. So does misrepresentation. Prosecutors assess whether access was leveraged, whether information flowed improperly, whether decisions created predictable private gain. The review is transactional and temporal. Who invested and when? Who spoke and to whom? What policy signals preceded market positioning? This is how influence cases are built, not through motive alone, through records, emails, briefings, contracts, bank transfers. The Greenland focus adds foreign dimensions: cross-border regulation, allied sovereignty, international compliance. That complexity increases exposure. It also limits political defenses. Law applies regardless of strategic framing. Investigators are isolating facts from narrative. The outcome depends on documentation, not rhetoric. Rare earth resources elevate national security stakes. These materials are not abstract commodities. They sit at the core of modern state power. Defense systems rely on them. Guidance systems, radar, communications infrastructure. Advanced manufacturing depends on stable access. So does energy transition technology. Control over supply chains is strategic leverage. That is why Arctic regions matter. That is why Greenland matters. Any shift in access affects allies and rivals alike. Policy decisions here are not symbolic. They shape long-term security posture. They influence procurement planning. They affect alliance trust. When executive advocacy centers on resource access, scrutiny follows. Because national security justification carries exceptional authority, it bypasses ordinary political debate. It accelerates decision-making. It limits transparency. That power demands insulation from private interest. Otherwise, legitimacy erodes. Investigators therefore treat resource policy differently. They assess whether security language masked economic intent, whether urgency displaced safeguards, whether strategic framing narrowed oversight. The higher the security stakes, the lower the tolerance for ambiguity. Institutions are expected to overcorrect, not assume good faith. That standard applies regardless of office held. Conflict of interest thresholds examined by investigators. These thresholds are legal, not ethical abstractions. Federal law sets disclosure obligations, recusal requirements, prohibitions on self-dealing. Investigators examine whether any actor crossed them, not through intent alone, through structure, timing, benefit. They ask whether officials or intermediaries acted where interests overlapped, whether influence substituted for process, whether private exposure created predictable outcomes. Conflict law does not require a quid pro quo. It requires material overlap, undisclosed alignment, foreseeable gain. Prosecutors compare internal knowledge with public action. They track who knew what and when. They analyze whether safeguards were bypassed, whether advisory roles blurred into advocacy, whether distance from decision-making was maintained or simulated. These thresholds are bright lines in statute. They are not flexible norms. Crossing them converts policy into liability. The presence of foreign jurisdictions raises the bar further. International dealings heighten reporting requirements. They reduce tolerance for informal channels. Investigators treat these cases conservatively. They assume institutional risk until disproven. That is why conflict analysis often expands investigations. It multiplies witnesses, documents, exposure. Presidential policy actions intersect with private benefit. This intersection is where legal exposure concentrates. Policy authority is broad, but it is not personal. When official actions align closely with private gain, scrutiny intensifies. Investigators examine whether outcomes were incidental or engineered. They analyze policy sequencing, public statements, internal briefings, external positioning by private actors. The question is not motive alone, it is foreseeability. Could a reasonable official anticipate private benefit? Was that benefit disclosed? Was distance maintained? When associates stand to gain from policy shifts, recusal norms apply. If recusal is absent, explanation is required. If explanation is missing, exposure grows. This is especially sensitive in foreign policy. Diplomatic leverage can create immediate market effects. Access can move capital. Silence can signal intent. The law treats proximity to power as a multiplier. The closer the relationship, the higher the duty of care. Failure to manage that duty transforms discretion into risk. This is why investigators focus on alignment patterns, not single acts, repeated convergence of policy and profit. That pattern invites enforcement. DOJ independence questioned amid active investigations. Institutional credibility depends on separation from political command. The Justice Department is structured to resist influence through career prosecutors, through internal review, through norms of insulation. When investigations touch executive interests, those safeguards are tested. Public directives and commentary complicate that test. They create appearance concerns. They raise questions of selective focus. Investigators must demonstrate autonomy through process, documented decision-making, clear jurisdiction, consistent application of standards. Any deviation weakens outcomes. Defense arguments grow stronger. Public trust erodes. This is why oversight matters during investigation, not after. Congress monitors procedure. Courts monitor fairness. Inspectors general monitor conduct. When independence is questioned, every action is re-examined. Delays attract suspicion. Speed attracts skepticism. Neutrality must be visible, not assumed. The department operates under that constraint now. Its handling of politically adjacent cases will define institutional resilience. Attorney General authority scrutinized for institutional integrity. The office carries unique constitutional weight. It controls prosecutorial discretion. It sets enforcement priorities. It safeguards the boundary between law and politics. When investigations implicate executive allies, that boundary is tested. Scrutiny is not personal. It is structural. Observers examine whether established protocols are followed. Case assignment, recusal decisions, delegation to career officials, documentation of prosecutorial judgment. Any deviation becomes material because authority without insulation invites challenge. The Attorney General is expected to restrain, not amplify, executive interest. Silence can matter as much as action. So can timing. So can selective urgency. Institutional integrity depends on predictable process, not outcomes. If discretion appears aligned with political interest, confidence degrades. That degradation affects future cases, not just this one. Courts weigh independence when evaluating prosecutorial decisions. Congress weighs it when considering oversight or statutory reform. The Attorney General's conduct therefore shapes institutional standing beyond any single investigation. NATO and Denmark diplomacy implicated by resource access. Greenland is not a bilateral abstraction. It is tied to Danish sovereignty. It sits within NATO's Arctic framework. Any shift in access alters alliance dynamics. Diplomacy here requires consensus, not leverage. When resource policy intersects with security commitments, coordination is mandatory. Unilateral signaling creates friction. Allies assess intent as well as outcome. If private interests appear embedded in strategic advocacy, trust weakens. Alliance decision-making depends on credibility, not pressure, not transactional logic. Foreign partners monitor internal governance closely. They assess whether commitments are durable or personal. That assessment affects cooperation, intelligence sharing, defense planning, joint investment. Investigators understand this dimension. They consider whether actions exposed allies to risk, whether diplomatic norms were bypassed, whether informal channels substituted for formal agreement. International implications amplify legal consequences. They introduce treaty considerations, foreign lobbying rules, cross-border compliance standards. This expands exposure beyond domestic law. It also raises reputational costs. Institutions are judged externally as well as internally. Congressional oversight risk escalates as facts emerge. Oversight activates when executive conduct intersects with enforcement. Committees request records. Testimony follows. Jurisdictional lines sharpen. As prosecutors establish timelines and relationships, Congress evaluates governance failure. The threshold is not criminality alone. It is institutional breakdown. Lawmakers examine whether safeguards were ignored, whether disclosure regimes failed, whether policy was distorted by private alignment. Oversight hearings do not require indictments. They rely on evidentiary sufficiency, public interest, systemic risk. As facts solidify, political insulation weakens. Party alignment becomes less reliable. Members assess exposure by association. That recalculation drives oversight intensity. The process is cumulative. Each document narrows ambiguity. Each witness clarifies sequence. Congress acts when narrative hardens into record. That moment appears closer as investigations advance. Rule of law stress test enters enforcement phase. This phase is procedural, not rhetorical. Institutions must demonstrate function under pressure. Investigators apply statutes without regard to office. Courts demand consistency. Oversight demands transparency. The stress test is whether norms hold, whether independence resists command, whether accountability mechanisms activate without crisis escalation. Enforcement is the measure, not statements, not assurances. When law intersects power, Delay signals weakness, overreach signals politicization, balance is narrow, failure is visible, success is quiet, the outcome shapes precedent. Future administrations observe response patterns. They adjust behavior accordingly. This moment defines boundaries. Either they constrain authority or they erode. The investigation now exposes more than individual conduct. It exposes structural weakness. Private financial interest appears to have moved alongside public authority. Disclosure safeguards failed to reassure. Recusal boundaries were unclear. Institutional distance was not visibly enforced. At the same time, enforcement credibility was strained by political proximity. That combination is the failure, not a single decision, not a single actor, but a system under pressure that did not clearly separate power from profit. The warning is procedural. If accountability mechanisms are delayed or selectively applied, the precedent will harden. Future administrations will test those limits further. What is tolerated now becomes normalized later. This case will not be resolved by rhetoric. It will be resolved by evidence, oversight, and institutional response. The outcome will define whether constitutional guardrails still function under strain. For continued legal analysis, institutional context, and fact-driven reporting, subscribe to stay informed.